Welcome to this brief overview of the Nevada Open Meeting Law. If you're watching this because you're an elected or appointed official serving in Carson City, this presentation will provide you with some of the basic legal rules that you should know in order to conduct your public meetings in a way that's compliant with both statutory and common law requirements. If, on the other hand, you're watching as a citizen who simply wants to learn more about the open meeting law, welcome. You've come to the right place. Today, we'll be talking about certain requirements that were established by the Nevada legislature to ensure transparency in how public meetings are conducted, and which guide a public official when that official is participating in a public meeting. Please keep in mind, though, that there is a lot, both in statute and in case law, that drive the open meeting law. Although we won't have enough time to go over every single requirement, I'll do my best to go over some of the most important parts. So, what exactly is the open meeting law in Nevada? The open meeting law, NRS 241.010 to 241.040. Those are the statutory provisions codified in Nevada revised statutes, which require certain meetings to be open to the public and conducted in a certain way. That includes, for example, meetings of the Carson City Board of Supervisors, the Redevelopment Authority, the Planning Commission, and many other boards, committees, and commissions that operate as a public body in Carson City, whether created by statute, city ordinance, or the Board of Supervisors under authority of state law or the city charter. The legislature had a certain purpose in mind when enacting the open meeting law provisions. In enacting this chapter, the legislature finds and declares that all public bodies exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. These are the foundations of the Nevada Open Meeting Law. There has to be a public body. There has to be a meeting. Before the meeting, there has to be a notice, and there also has to be an agenda that shows the public what is going to be presented before the public body. Finally, after adjournment of the agenda, there must be a preparation of minutes in a timely fashion. The open meeting law is made up of 5 main parts. First, it only applies to public bodies. A public body is any administrative, advisory, executive, or legislative body of the state or a local government consisting of at least 2 persons which expends or disperses or is supported in whole or in part by tax revenue, or which advises or makes recommendations to any entity which expends or disperses or is supported in whole or in part by tax revenue, including, but not limited to, any board, commission, committee, subcommittee, or other subsidiary thereof. Wow, I know that's a mouthful, but please stay with me. The open meeting law does not apply to meetings of non-governmental entities, and even some governmental entities are expressly exempt from the open meeting law provisions. For example, the open meeting law does not apply to the Nevada legislature, most judicial proceedings, certain meetings of the State Board of Parole Commissioners, and other meetings where state law specifically provides that the open meeting law does not apply. But then, what is a meeting exactly? A meeting is a gathering of members of a public body at which a quorum is present, whether in person or by means of electronic communication, to deliberate toward a decision or to take action on any matter over which the public body has supervision, control, jurisdiction, or advisory power. This includes any series of gatherings of members of a public body at which less than a quorum is present, whether in person, by means of electronic communication, at any individual gathering, the members of the public body attending one or more of the gatherings collectively constitute a quorum, and the series of gatherings was held with a specific intent to avoid the requirements of the open meeting law. So, we've heard a lot of different key terms here. Let's think about each one. What's a quorum? A quorum is a simple majority of the membership of the public body or another proportion established by law. If, for example, there are only 2 members, then there can't be a meeting for purposes of the open meeting law because there is no quorum. Also, for there to be a meeting, there must be at least 2 members on the public body. For example, there are certain administrative meetings that are conducted by 1 hearing officer. Under those circumstances, there is no quorum of 1 and the open meeting law would not apply.
If all 5 members of the Board of Supervisors gathered for no purpose other than to discuss whether there really are UFOs and aliens on Mars, that wouldn't constitute a meeting. That would be subject to the open meeting law because remember, the meeting has to do with a matter over which the board has supervision, control, jurisdiction, or advisory power.
Now, let's talk about what it means for a public body to act or deliberate.
Action. That's a decision made by a majority of the members present during a meeting of the public body, or a commitment or promise made by a majority of the members present during a meeting of the public body. Deliberation. That means to collectively to examine, weigh, and reflect upon the reasons for or against the action. That term includes, without limitation, the collective discussion or exchange of facts preliminary to the ultimate decision. Social functions are also not subject to the open meeting law so long as there is no deliberation over matters. Attorney conferences are also not subject to the open meeting law. These conferences fall outside the meaning of meeting for purposes of the open meeting law and are exempt even if the members of the public body are deliberating towards a decision for existing or potential litigation. But there can be no action taken which, if you'll recall, is the making of a decision, a promise, or commitment, or coming to a consensus.
Let's talk for a moment about electronic communications.
In addition to in-person meetings, members of a public body may also participate and vote on matters during a public meeting electronically, meaning by telephone or video conferencing. However, if a member is allowed to be present telephonically or through video conferencing, the public must be able to hear or observe what is happening.
Another important thing to remember about electronic communications is that they must not be used to circumvent the spirit or the letter of the open meeting law. The entire purpose of the open meeting law is to facilitate transparency in government by requiring actions and deliberations to be taken and conducted openly, so that the public always has an opportunity to know what the government is doing. Members of a public body must exercise great care in avoiding what's known as a walking quorum, which can more easily happen inadvertently through the use of an electronic device, such as a cell phone or computer. Let's take a look at this scenario.
Hello?
Hey there, it's me, Adam. I'm going to vote yes in that land issue tomorrow. How about you?
Great, I'm going to vote yes too. I'll reach out to Tony, okay?
Perfect. What's up, Debbie?
Hey, Tony, I just spoke with Adam, and we're both going to vote yes on that land issue tomorrow. We want to know if you're on board.
Okay, cool. No need to talk with Bert or Harry, because that's 3 votes for us. Brilliant.
In that scenario, we had a walking quorum that was made possible by a series of telephone calls, which would violate the open meeting law. But it doesn't just have to be phone calls. The same violation could happen with, for example, fax or email communications. The lesson here is to always be mindful of serial communications between members of the public body. If you're a member of a public body and you receive an email about a topic that falls under the jurisdiction of the body that you're serving on, always remember to check who's all on the email. Check the recipient list, check the blind copy list. Remember that the open meeting law also applies before and after a meeting, so members of a public body must also avoid talking about matters within the jurisdiction of the public body before a meeting convenes and after a meeting adjourns, or during recess, because those discussions could easily turn into a deliberation. The practice pointer here is to confine those types of discussions to discussions on the record. The open meeting law doesn't apply to meetings among staff. So for example, if Carson City employees gathered to discuss an item that will be appearing on a future agenda as an item for discussion or action, that meeting would not be subject to the open meeting law provisions. Additionally, private meetings between staff and a non-quorum of public body members would not violate the open meeting law. All right, let's talk about a few notice requirements now.
Notice must be given at least 3 working days before the meeting. Notice must include the time, place, and location of the meeting, and various other information. The agenda must consist of a clear and complete statement of the topics to be considered. Discussion, deliberation, and action must stick to the agenda. Remember, this is part of the public's right to know. Items on which action may be taken must be denoted as being for possible action. Otherwise, the board, committee, or commission may not take action on that agenda item. And lastly, but not least, there must, at a minimum, be 2 periods for public comment.
Certain requirements must be met to satisfy the public's right to know. Notice of a meeting, which is oftentimes the agenda itself, must be posted at least 3 working days in advance of the meeting. Of course, it must also list the date, time, and place of the meeting, and it must be posted in certain other locations as required by statute. These requirements, including requirements related to how an agenda title should be worded, are all set forth in the provisions of NRS 241.020. For Carson City public body notices and agendas, members of public bodies can rely on the assistance of staff and the district attorney's office to ensure that posting requirements and other legal requirements relating to the content of an agenda are all satisfied. Public comment is something, however, that the members of a public body need to give special attention to. At a minimum, public comment must be taken
At the beginning of the meeting, before any items on which action may be taken are heard, and again before the adjournment of the meeting, or after each item on the agenda on which action may be taken is discussed by the public body, but before the public body takes action on the item. A public body may impose certain restrictions on public comment, but those restrictions must be stated clearly on the agenda. Those restrictions must also be content neutral. Comments that are unduly repetitious, slanderous, or irrelevant to the public body may be limited as well. Reasonable rules of decorum may be imposed, and disruptive behavior may be prohibited. Reasonable time restrictions may also be imposed, but that must be uniformly imposed on all speakers.
Let's consider this next scenario.
Mr. Chairman, I have come to you today to express my concern about an issue of great importance in this community, and that is alien abduction. It's happening right now in this here community, right now.
Is this the type of public comment that must be allowed? Well, the answer is
figure it
no. Unless this public body was formed to
I am
have some type
hearing
of authority
something.
over UFO-related matters, this public
What
comment
is
is irrelevant
that?
to the public body.
Who is
The manner in which
that
the comment is
person?
given is also disruptive,
Go
and so the
away,
chair of the public
person.
body
Go
may
away.
restrict the comment.
I cast ye out.
Good morning, honorable members of the committee. I am here in opposition to this agenda item. I know you have been working on this item for a very long time, but I just do not think it is a good idea.
Are you kidding me? Ugh! You know this is my measure, right? You come in here, if you don't understand how good and right this is, then you're too stupid to even be heard. Just go sit back down, for crying out loud. Jeez.
Was that restriction permitted under the open meeting law? The answer again is no. The person speaking was not disruptive in any way, had not exceeded any time limit, and was speaking on a matter under the jurisdiction of the public body. He was cut off because the chair simply did not like his perspective, and that's probably viewpoint discrimination, which would be unlawful. Now, here are some other points to remember about public comment periods.
During public comment, members of the public body are not required to respond to the public comment. However, members are not prohibited from responding to public comment. Public comment, nonetheless, should be dedicated as time to the public, and therefore, members ought to refrain from excessive comments themselves. Meeting materials that must be provided to the public at no charge include a copy of the agenda itself, any proposed ordinance or regulation that will be discussed at the meeting, any other supporting material provided to the public except for materials that are confidential or proprietary information pertaining to the closed portion of a meeting or otherwise declared confidential by law. At least one copy of the agenda, any ordinance or resolution, and supporting material must be made available to the public at the meeting. Minutes must be kept of each meeting, including the date, time, and the place of the meeting. The minutes must reflect attendance of public body members, and it has to indicate who was present and who was absent. Minutes must also include substance of all matters proposed, discussed, or decided. And they must include substance of remarks made by the public. Minutes must be approved by the public body within 45 days after the meeting or at the next meeting, whichever is later. Finally, minutes are considered public records, and either minutes or an audio recording must be made available for inspection by the public within 30 working days after adjournment.
We've now gone over some of the most fundamental aspects of the Nevada open meeting law. So what happens if there's a violation? The Office of the Attorney General has primary jurisdiction to investigate violations of and enforce compliance with the open meeting law. If a violation is found to have occurred, any action taken in violation of law is void. Violations can also result in misdemeanor charges, as well as a $500 civil penalty for each violation.
Different sources of information that you may also find helpful include case law that can be found in the annotations to NRS Chapter 241. NRS is available on the Nevada Legislature's website, but annotations to case law are not. Annotations can be viewed by using legal research programs or by visiting your local law library, including the Nevada Supreme Court Library. You can also view and download a copy of the Nevada Open Meeting Law Manual and official legal opinions of the Nevada Attorney General's Office, which can be found on the Attorney General website.
Hopefully, this brief presentation has been helpful to you. If you're an elected or appointed member of a public body in Carson City and you have additional questions that require a more detailed analysis of the open meeting law, as well as any questions related to your voting and abstention requirements under ethics laws, please do not hesitate to contact the District Attorney's Office. Thanks for watching.